That's the evidence on behalf of the accused, sir.
Sorry, that's the end of the, you can sit down. Reply evidence, Mr. Houle?
No, thank you.
Do either of you wish some time to prepare your argument, or Mr. Marley, since you called evidence, you will argue first?
Thank you, sir. I'll address, first of all, the bodily harm component of count number 1. Whether or not you ultimately find that an assault occurred, in my respectful submission, the evidence that you have before you, in particular from Officer Fantasia himself, in my respectful submission, does not make out the component of the offense or the essential element of that offense of bodily harm. In my respectful submission, the only thing you can take away from the evidence that you've heard is that the injury sustained as a result of my client punching him in the face or on the jaw was simply transitory and trifling in nature. It did not require anything other than one attendance to a doctor. He did not go back and follow it up. There's no evidence of there being any broken bone. So in my nor any other type of injury which would constitute bodily harm. So in my respectful submission, the accused jeopardy at its highest in relation to count 1 is for the offense of assault. In relation to both counts 1 and 2, there are really 2 physical transactions which the Crown will point to in order to evidence an assault perpetrated by my client. The first is my client's removal of Officer Fantasia from on top of Mr. Friedbrain, and the second is the punch.
Is that in count 2, or is that in count 1?
Pardon me, sir?
The removal in count 1, is that the assault in count 1, or is the removal and the punch the assault in count 2?
I've not sought particulars in relation to this case, but it would be my view that the assault which is set out in count 1 must be the punch, because that's the only assault which could have caused bodily harm, if in fact there was bodily harm. In other words, the only injury that could have constituted bodily harm would be the punch to the jaw. So I'm assuming from that either it is the punch which is the subject matter of both charges, or that the removal of Officer Fantasia from on top of Mr. Friedbrain is the subject matter of count number 2.
Well, the removal is a touching without consent.
Yes, sir.
So you've got 2.
That's right. And that's why I say, at most, there are 2 physical transactions that arise from this evidence and that are subject matter of these charges. And I'd like to address each of those physical transactions. And then if there's anything which Mr. Houle says in his submissions, which I have overlooked, I'll address in reply. But in my respectful submission, the first physical transaction is excused by Section 37 of the Criminal Code.
37 or 27?
I believe it's 37, sir, that permits, that excuses.
37 permits somebody who's under your care, if I'm not mistaken. And I don't know that Mr. Friedbrain was under Mr. O'Brien's care.
I agree with that, but I also agree that in my
But if you look at Section 27, that appears to be the Good Samaritan section.
Yes, sir. I'm sorry. And Section 27 of the Criminal Code, in my respectful submission, excuses this gentleman's conduct insofar as the removal of Officer Fantasia from on top of Mr. Friedbrain. And his actions, in my respectful submission, based on his own evidence, but based on the evidence of Mr. Friedbrain, and also, to an extent, the Crown evidence, which at least describes the positioning of Officer Fantasia over top of Mr. Friedbrain, in my respectful submission, ought to lead you to the conclusion that the Crown has not established that that offense does not apply, because that's the Crown's obligation in the context of a case such as this. In my respectful submission, you also have to consider, in relation to the second physical transaction, the provisions of Section 34.
That's the self-defense section.
Yes, sir.
The
And the
punch
logic is,
the punch
I'm
is
sure-
Section 34.
Pardon me?
The punch is Section 34.
Yes, Your Honor. And the logic, I'm sure, is apparent to the court. I'll repeat it briefly just so that the court has on record my submissions. But it is my respectful submission that the Crown cannot negative that at the time that he punched Officer Fantasia, that Mr. O'Brien reasonably feared for his safety as a result of what had transpired up until that point, and then by what can only be described as a provocative move on the part of Officer Fantasia to have reached inside his pocket. And when you consider in particular the time frame within which these events occurred, in my respectful submission, that defense is borne out. Your Honor, in my respectful submission, ought to accept the evidence of Mr. O'Brien, notwithstanding his testimony to the effect that his recollection in some respects is shady. Much of what he says in terms of what happened is borne out by the evidence of the other witnesses, the order in which things happened, the possibility that he had not heard anybody say the word police prior to him having administered the punch. Mr. Friedbrain's testimony about being assaulted by Officer Fantasia prior to Mr. O'Brien removing him. In other words, notwithstanding that there may be details about which my client's evidence was shady, he was clear not only about what he did and why he did it, and much of what he testified to is borne out or corroborated by other evidence, not only called by the defense, but called by the Crown as well.
Well, I agree that there's some confirming evidence in the Crown's brief, but your client himself, I suppose it's a double-edged sword. I'm sorry, not your client. Mr. Friedbrain says, I have an animus towards Officer Fantasia. He conceded that he and the truth were, quote, not friends. So it seems to me that I should, based on those admissions alone, at least treat Mr. Friedbrain's evidence with some skepticism, while their corroboration, and it's not a Vetrovec issue, but confirming evidence might be required if I'm going to accept Mr. Friedbrain's evidence.
And that was my next point, actually, because I agree with you that you must approach his evidence with some caution. I led his record, alerting the court at the outset to the fact that this is a witness for whom you would have to look for corroboration in other evidence in order to be able to accept his testimony. But there is evidence of how he was positioned vis-a-vis Officer Fantasia. There is corroboration for the proposition that Mr. Friedbrain testified to, that Officer Fantasia reached into his pocket. That confirmation doesn't just come from my client, it comes from Officer Fantasia himself.
And Ugart.
Pardon me?
And Ugart, I think.
Yes.
Was it Ugart?
Well, no,
No, Ugart didn't see.
Ugart says he saw the whole transaction, but didn't see Officer Fantasia reach into his pocket.
That's correct.
In any event, in my respectful submission, Your Honor, there are confirmatory aspects, or there are other aspects of the evidence which confirm what I submit are the essential components of Mr. Friedbrain's evidence. So notwithstanding the fact that you must caution yourself in terms of considering his evidence, I don't quarrel with that proposition at all. In my submission, there is confirmation for you to find that his evidence is truthful. And while had Mr. Houle pursued the issue about whether or not Mr. Friedbrain was friends with the truth or not, I may have objected. That answer came out before there was an opportunity to reasonably object.
I think, I don't see anything wrong with, I mean, if Mr. Houle had said to Mr. Friedbrain, you're lying, that's a perfectly valid suggestion. Presumably Mr. Friedbrain actually said, I am a stranger, or I am not great friends with the truth. I do have an animus, but I'm here to relate what I saw. And that goes to assessing his credibility.
That's right. And he did essentially say that in his testimony, and in my submission, it does assist you in properly assessing his credibility. He was not the most forthright witness. He was reluctant to some degree. He obviously has an animus vis-a-vis Officer Fantasia, But in my respectful submission, none of that takes away from what he saw, particularly those aspects of his evidence which assist my client's defense and which are confirmed by other evidence called in this trial. So in my submission, there was a value in calling him as a witness, and it assists you in finding, at the very least, that the Crown has failed to meet its standard of proof beyond a reasonable doubt in relation to these two counts. In relation to the Crown evidence, I will only comment on there being a couple of marked discrepancies in the testimony between Officer Fantasia and Officer Ugart. One of them has to do with the fact that Officer Fantasia insisted he was pushed by Mr. Friedbrain before taking him to the ground, whereas Officer Ugart, from 100 meters away, offered the evidence that he saw punching and kicking. Officer Fantasia insisted that he said something to Mr. O'Brien about being a police officer before Mr. O'Brien intervened in this altercation, although he acknowledged the reasonable possibility that Mr. O'Brien did not hear it. But Officer Ugart, who's running towards this event, doesn't hear Officer Fantasia say anything. So in my respectful submission, to the extent that the Crown has to establish for you beyond a reasonable doubt as an essential element of count number 2, that Mr. O'Brien knew or was willfully blind to the fact that Officer Fantasia was a peace officer, in my submission, the evidence fails, even on the basis of Officer Fantasia's testimony coupled with Officer Ugart's testimony. I would also ask you to consider...
It may be that Ugart didn't hear it because he was running and yelling at the same time.
Maybe. It may be. And so the discrepancy in their evidence on that point may not have much meaning. However, looking at all of the evidence offered by the Crown in my submission, even at the end of the Crown's case, you ought to have a reasonable doubt as to whether or not this man knew or was willfully blind to the fact that Officer Fantasia was a police officer engaged in the lawful execution of his duty. Thinking again about Officer Fantasia's testimony, in my submission, you ought to have a reasonable doubt as to whether he was engaging in the lawful execution of his duty as well, given the nature of his contact with Mr. Friedbrain, who was apparently completely lawfully in that park. He had no right to insist that he leave. Whether it was a direction or an insistence or a request really doesn't matter, because it's obvious from everyone's evidence that things got heated between them. And Officer Fantasia, in my submission, exceeded what authority he had by trying to direct Mr. Friedbrain out. Now,
Well, that's certainly in respect to Mr. Friedbrain.
Right.
Does that affect his duty with respect to Mr. O'Brien?
well, in my respectful submission, it gives you absolutely no basis on which to be able to conclude that this man, who doesn't come upon the argument, who doesn't come upon the kick or the punch or the push, if there were any of those, Mr. Friedbrain says there weren't, who doesn't come upon the taking to the ground. He doesn't see any of that. What he sees are two people dressed like people who normally occupy that park on the ground, struggling. So in my respectful submission, the Crown can't point to anything in what he saw at that time, either the knowledge or the willful blindness about the fact that Officer Fantasia was a police officer. Coupled with Officer Fantasia's concession that this gentleman may not have heard what he said, coupled with this man's denial that he heard what Officer Fantasia said. In my respectful submission, that element of the offense hasn't been established either. So for all of those reasons, Your Honor, I would urge you to find Mr. O'Brien not guilty of both of these counts. Unless you have any further questions of me, sir, those are my submissions.